this FDP on intellectual property rights. I think we have been discussing a lot on like, what can be IP protected, what do you mean by IP, how is the protection taken, as well as I think there was a part of discussion wherein from filing till grant, that entire journey, I think that was covered by Dhanashri yesterday. Or, no, sorry, I think she covered the drafting part. Yes. Am I correct? Right? So it was some chair ka example she had shared. You enjoyed it actually. Now you can draft it. You don't need an agent now. Maybe. Okay, I'll prove you wrong. Since we are on the fourth day, let's at least I can see some of the participants, like, the faculties at least, like, you have been listening to all these sessions since last 4 days. So let's quickly recap. In the meantime, the others would join, right? I have conducted more than 300 sessions pan-India, offline. I have visited 30 states. I have trained faculty members. I have trained school students on IP. I have trained lawyers. I have trained the startup founders. I have trained MSME professionals. I have trained customs officials, like, those who are at the borders or the ports or the airports actually. So cutting across the, I would say, sectors, cutting across the age groups. The youngest, I would say, student of mine is my 5-year-old daughter, and the eldest one, like, I've trained people who are 70, 75 plus as well. That's how, like, the IP actually works. During all these sessions, I have been repetitively being asked with the same questions again and again. So I thought, let us do one thing. Let me list those questions for you, because many of you would have the same questions, and since we are on the 4th day, we'll try to answer these questions one by one. And I am sure now, at least at this stage, you are in a position to answer some of these very easily. Okay, this is for, especially the first 2 slides are for patents, scientific inventions basically. The very first question that is being asked is, when should I file a patent application? At what stage of my research should I file a patent application? Before publishing in a journal, that's for the novelty purpose. But let's not think of anything else except your research. At your research, you have different stages, like, you have the hypothesis, you have a literature survey, you procure the materials, you get connected with the people, what studies are required, like, and then you conduct the experiments, and then you have the thesis. At what stage should I go for patent filing? What's the most ideal stage? Just before? Okay, I'll tell you how it actually practically works. We have a system, and there is a rationale why I'm saying so. We have a system which says first to file. Means the one who files first gets the patent. So what we recommend as a practice is, the moment you have hypothesis, you should go for provisional patent filing. You don't need to wait. See, if you are very much confident कि ये work करेगा, that point of time you don't have problem with like, filing a patent application. If you are not confident enough for your research or thesis, probably that point of time don't go for provisional. What you do, wait till all your studies are done, and thereafter you have a complete filed directly. Remember, provisional is optional actually. And why I'm saying so has something to do with the last question. Can someone else file patent application of my invention? We're sharing the labs. We are sharing, at our time we used to share the systems, desktops as well. Is it possible that my data is being taken by someone else? There is a high probability, and India में तो हर चीज possible है, practically.
We are giving it to photocopy purpose.
Whatever, for whatever purpose you are actually. So, in fact, this was one of the questions asked, and I had some very interesting live example case studies as well. I'll discuss ki how does it practically work and how to resolve it. And that also gives us an idea about our tomorrow's sessions about the startup, the IP policy and why is it required and what all should be there as well. Practically speaking, patent office never asks you where did you carry out the invention, who carried out the invention. It is all through self-declaration. Just those 1, 2, 3, 5, whatever forms are there, these are self-declarations. And when we think of self-declaration, we know, like, in India, तो लोग notarize affidavit गलत दे देते हैं, तो self-declarations are easy things, like, So anyone else can. So there is no control. Of course, there is a legal system ki if someone else files invention, like, which is my invention and someone else files, there is a legal way to overcome it. You have to approach patent office with certain proofs that the invention was either taken without my consent actually, or there is a proof that I had shared this for the way sir said. मैंने photocopy के लिए दिया था, ये बंदे ने अपना खुद का patent file किया. That's the reason. Now to avoid this, see, since morning मुझे 3 लोगों ने पूछा ये क्यों पहना है. This is precaution. कुछ हुआ नहीं है, मुझे मेरा accident नहीं हुआ है. This is just a precaution. Now I think this is much better than before any damage is done. That's where I say, you file a provisional before someone else gets access and files it. That's the one way to look at it. So, and as I said, the first to file system simply says the one who files first gets the patent. Now there is also I think one more reason we do this as such, like, the filing first. Reason being, imagine a situation that some of your students leave the institute or your colleagues leave the institute and they know about your research. There is a probability they would continue working on that. Or let us be really grounded and practical. हम दुनिया से अलग कुछ नहीं कर रहे हैं. Same research paper से inspire होके, जिस research paper से inspire होके आप अपना project कर रहे हो, उस research paper से inspire होके there may be 100 labs which would be working on the same idea. The very first thing that we should remember is that, okay, you file it first. So because we have the first to file system, irrespective of, like, for example, it may happen, you do it earlier, but someone else, takes it ahead and they file it first actually. Then they would be the one who would be getting. That's the reason it is very essential to file first. Second one, why should I file patent application? I think we have been discussing this since 3-4 days. It's for the academic institutions, definitely it's because of NIRF and NAC, there is a lot of, I would say, awareness about IP, and that's the reason there are a lot of IP filing. I'll practically tell you how it is helping. So this happened in 2018. So Mumbai University, so this girl was doing her master's in pharmacology at one of the institutes in Mumbai. During her B.Pharm, she was a university topper for all semesters, 8 semesters basically. She was a university topper. There was this one funding for master students. It was a travel grant for 1 week to UK, London. She was pretty excited actually, and of course her CV was really nice. All semester university topper and all, she was super excited actually. She was one of our clients, as in we had filed a patent application for her. I can actually connect with that girl as well, those who really want. Now what happened is, as I said, Mumbai University, premier university in India, university topper. So the interviews were in Delhi. When she went there, almost I think 100 plus students there. When she went there, she realized at least 30 से 40 तो university toppers हैं. We have so many universities in India. She was a bit skeptical now, like, you know, कि अब थोड़ा सा confidence level down हो गया. She called me up. It was early morning around 10ish, like, you know. She said, sir, मुझे नहीं लगता मुझे मिलेगा. यहाँ तो बहुत सारे university toppers हैं मेरे. And this is the actually harsh reality of education system, right? Now, cut to the end of the day. एक तो उसका surname end में, मतलब because of the alphabetical, उसका interview last में था. Now what happened is, they were literally grilling. Of course, funding है, travel grant है, government grant for a week to UK. So like it means a lot actually. Like they were grilling like 30-40 minutes. ये लड़की का जब turn आया, it was almost 7. She was super exhausted, tired, sitting there, and the more she was there, वो negative thoughts आ रहे थे, like, you know, because she was जाते हुए तो बहुत confidence level के साथ गए थे, right? 7, 7:30 बजे जब उसका turn आया, she went inside. She was given just 90 to 100 seconds inside. When she came out, she literally started crying. मुझे तो कुछ पूछा भी नहीं. But there was one unique thing, actually. This is cut to 2017, not 17-18, not today. Like, you know, now to, there is a lot of awareness about IP and all. She was asked just one question. Why did you file a patent application for whatever research you did? So she had done a UG, during her UG she had helped someone with a project. Why did you file a patent application for that invention? This was the only question I was like, you know, I had told her to prepare for. Now, the uniqueness therein was, out of those 100, she was the only one who had a patent filed for a UG project. That gave her, and when she got the results, she was the one who was selected, actually. Now that is, for me, like, you know, वो patent बाद में grant भी नहीं करवाया उसने, वो lapse हो गया, absolutely fine. Agenda क्या था? वो patent file कुछ credibility credentials के लिए उसने उस time पे. My purpose is done actually, like, you know, why are we filing the patent? A very strong answer I have got here for students as well, like, you know, when they go out, when we see so much of competition basically, it at least, I would say, for the purpose of, like, you know, making their, let's say, profile unique, which stands out of others, because that's where the opportunity comes from. At least opportunity मिल रहा है वहाँ पे, right? And that's why I say, like, you know, and of course now everyone knows, you know, every institute. So during those days I was running after these institutes. Let us, like, you know, allow me to conduct a session on IP. No one was bothered actually. And now it's like almost every week or like, you know, every alternate week we are doing one or other session about IP cutting across India. Right, you know, so that's the significance and that's the reason, like, you know, now what data do I need to file patent application? कल drafting का exercise हुआ है, right? What data is required? Now the data is generally dependent on what you claim. But let me honestly tell you, there are examples you don't need to work in lab to file patent. If you have a hypothesis, and I think in my very first session I had told this, if you have a hypothesis, you can incorporate prophetic example. We call it hypothetical examples, those hypothetical examples may be the ones which can be part of the specification and you can get patent granted without carrying out the research work in lab. But is it that easy? Maybe therein you need more help from a patent agent. How to do that, how to draft that, what precautions should be taken actually. Patent office, as I said, would never understand kahan pe kab aapne research carry out kiya hua hai. But it really needs a smart drafting. Beyond this, as I said, maybe the answer was like you don't need to carry out research to get a patent. That may be long back, because nowadays there is so much of data available that it becomes really difficult to distinguish, and that's where we suggest at least one working example is something which is mandatory. But what happens, typically we get entire thesis, master's thesis or PhD thesis, which is many a times 200, 300 pages. The scientists say, sir, ये data बहुत crucial है. Okay, that data may be crucial for either commercialization or the science, not for me. For me, the data always depend on what is claimed. I'll share it with one wonderful example here. Can I publish my research before patent filing? No. Absolutely no, right? Can I publish my research after patent filing? Yes, there is no problem, correct? Because that doesn't act as a prior art. How much is the cost for patent filing? Is it covered? Yes, so you have 1600 rupees, which is a patent filing fees, 2500 optional early publication, and 4000, which is a request for examination. Everything else goes to agents or attorneys. This was in 2018. A girl from Nasik called me up. Those were early days when I was struggling with my business. Abhi start kiya tha, that point of time. This girl called me up, sir, मुझे patent file करना है. So, and that was through referral, किसी और के referral के through. The girl called me up. I was like, happy, chalo, business aa raha hai. She was not willing to. She didn't require to sign a confidentiality disclosure. उसने thesis भेज दिया अपना या whatever research project. We started drafting. Draft उसने approve कर दिया. She was a master student. Just before a day before filing, she called me up. Sir, I have a request. Of course, we got the list of inventors, उनके signatures वगैरह जो भी चाहिए था. I was not aware कि कौन guide है, कौन principal है, कौन director है, कौन मम्मी है, पापा है. मुझे कुछ नहीं पता था. We were just filing. She asked me one innocent question. Sir, can I file the patent application without including my guide's name? What's the answer? Can any student file a patent or design without telling the institute or guide?
Depends upon the policy of that college, I guess. If it is college project, then I think it's a property of that institute.
Okay.
In that case,
Okay, perfect. We have a IP policy. I was discussing with sir in the morning. Some policy in place. We have some students at the back end. All of you are students, right? Do you know there is an IP policy which exists and you can't file IP without telling the institute? Patent या design file करना है तो? They are not aware what is IP. Now, having a policy and actually letting them know, actually especially for the PhD students, especially for the master student, even your visiting adjunct or temporary faculties, ad hoc faculties as well, right? That is important. Patent office doesn't bar. Patent office never asks, right? One thing is, we have been hearing these words Gen Z and what was that boozy and all, since last 2-3 days. Now the question is it legal to file? Legally correct? That's the first question. And second question is it ethically correct? Or ethics or morals? The way I have dealt the Gen Zs in last 8 years, the second question is ruled out for me. Unfortunately, right? And most of the faculties would agree on this, on the moral part or ethical part. Like, is there a way to, I am not generalizing the Gen Zs or any specific generation, but ethically and morally, trusting is a difficult thing now. Agreed? Yes? Legally, it would be binding only when you have a policy which is, क्यों जब students आते हैं तो हम लोग उनको attendance policy बताते हैं, time क्या है, the college time, all the policies, कुछ institute में dress code होता है, वो सब बताते हैं. Right, those students especially who are joining for research purpose, masters hai, ya let's say even for that sake, the faculties and all, it is our duty as an institute to inform them what is the policy. I'll tell you how it actually works. When the students go and join any corporate, the offer letter has that specific clause mentioned. Offer letter has specific clause mentioned, whatever you develop during your association with the corporate. And I think there was a question someone had asked 2 days back कि मेरा intern अगर एक corporate में जाता है तो who owns the IP actually. So if there is an internship, as let's say the MOU, or if they are giving a letter, उसमें वो mention होगा that IP would be owned by the company and you cannot file the IP without telling the institute. So this is more legal and it is always better. Again, IP policy acts as a preventive deterrent measure that no one would dare to do that basically. Am I correct? Agreed, everyone? Now, next one is, from filing to grant, I'll be taking you through this journey of a patent. How does it actually go through different stages till grant? When does the application get published? So we have 2 systems. Anything, remember this, anything that gets filed gets automatically published without examination. That's the difference. I had one slide on day 1, research paper versus patent. Anything that you file, you take this paper, take this diary, put it in a format, it gets published. That publication is not a patent, it is merely an application. For example, university में एक PhD position है, university advertisement निकालता है, and that point of time 100 students apply for that. What university does is, university publishes the list of applicants. Now, does that mean all those 100 get the seat? No. So you have a whatever criteria is evaluated. Similar way, patent, whatever you file, कुछ भी document ले लो, किसी का भी उठा के ले लो, file करोगे in a proper format, it gets automatically published. The publication of a patent application doesn't have much of the value basically because it is yet not examined. Examination, and that's where the next question is, does publication of an application assure you of a grant? Absolutely no, because abhi examination baki hai. Does publication of that list of 100 students assure them a seat for PhD? Absolutely no. The examination happens and there is only one student who gets that seat, let's say, and that's what the granted patent is. That's the difference between a publication and a patent grant. Now, cost after patent filing till grant, I think on day 1 in the inaugural this was discussed. It all depends on the attorney charges, but then the basic fundamental fees of patent office are fixed basically. Patent and design ka kya difference hai that we have seen. I had this slide, but I think I didn't discuss the other day actually like in detail. Now this is how a typical, I would say, cycle from lab to patent grant and enforcement goes. You have a So very first thing, and I'll be taking you through this. Okay, now, when we have a thesis, when we have a project, the very first thing you need to do before patent filing is signing a confidentiality disclosure agreement or non-disclosure agreement even with patent agent. हम लोग भी इंसान हैं, अच्छा research आया तो instead of your name, I'll file it in my name. That's possible, right? Where is it written कि आपने मुझसे share किया है तो I can't file it in my name? And interestingly, I'll tell you, like you know, this was I'm from Latur, and Latur में एक case हुआ था हमारे यहाँ locally, जहाँ पे ना there was one guy, one professor who had done really nice research. वो dairy sciences का था, and then there were no agents or he didn't know any expert. So he knew one person who had done कोई certificate course in IPR, one-day certificate course in IPR कहीं हैदराबाद में, and तो उसके लिए वही भगवान था. उसको दिया अपना research, and ये बंदा अच्छा जो फाइल कर रहा है, जो खुद को भगवान बोल रहा है, उसको भी नहीं पता है करना क्या है. Killing the invention, he included his name as well. एक out of 5 application, एक में तो जिसका इन्वेंशन था उसी का नाम इंक्लूड करना भूल गया भाई. मतलब मैं आपके घर पे रेंट पे आ रहा हूं एंड मैं वहीं पे रह रहा हूं, आपको ही धक्का मार दिया मैंने बाहर करके. गेटिंग? सो ऑफ कोर्स दैट्स पॉसिबल. इंडिया में everything is feasible, so it is always better to like you know, have that precaution. Sign the very first thing. So in most of the cases we have CDAs on or we call it confidential disclosure or non-disclosure agreements signed with the institute or university itself. So you don't need to go to every scientist and sign it independently. If you are actually connecting with the agents individually, that point of time, like you know, and again, of course, most of the things are also based on the trust actually, like you know. So that's the first step. We file the, like you know, we get the patent, we sign the CDA, we get a actual entire thesis or a project report from the institution, and what we do is we create patentability report internally. जैसे examination report has multiple things, we do it internally. The way patent office does examination, we try to do it at our end based on our understanding of patent domain and the technical domain, and that's the second most crucial thing. I've been repeating this. कोई advocate है, कोई lawyer है, agent है, don't go to him if he or she doesn't understand your invention. आपका invention उसको समझ में आ रहा है क्या? See, what all need to be done once the agent has to understand the invention, he has to put it in a draft. Dhanashri mentioned me, some of you were very smart to use ChatGPT right away and start drafting. Okay, drafting is fine. ChatGPT is giving you, AI is giving you. I'll take you through some of these slides जो आपको बता देगी कि problem कहाँ पे आता है and कैसे वो grant में issue होता है basically. So first thing is drafting. चलो, AI solved it. Next is convincing the controller or the examiner to grant it actually, or to you have to convince them that this is the inventive step or this is the novelty in this particular invention. जब तक मुझे ही नहीं समझ में आ रहा, मैं कैसे बताऊं? Right? Now that's the reason I would say when you are selecting a agent or attorney, make sure he or she understands your invention. Patent office की site पे patent agent register करके है, which has all patent agent का list, including their addresses. Many people are like, you know, I've been getting this call from since 15 days to visit Nagpur. They want to see me. Actually, I'm working with some clients who are from Kerala or Tripura. I've never seen, मेरे सामने आए तो भी नहीं पहचान पाऊँ. But Nagpur people want to see me first. तो आप location wise भी अपने agents identify कर सकते हो, qualification wise भी, right? So you can actually search that. Everything is there on the patent office site. The name is Patent Agent Register. उसमें search कर लो, मेरा भी नाम दिखेगा. In fact, there would be a code 1096 which is my patent agent registration number. Okay, if you are filing on your own, you go. If you are filing on your own, you go. So you don't need to go virtually, ma'am. It's virtual firstly, and secondly, if I am representing, let's say you or anyone, you are also allowed to join for the hearing. That I will take you through that actually, right? You can join it as such, right? So हम लोग क्या करते हैं? Patentability report generate करते हैं. We share it with the client. We tell the client that okay, this is patentable. That the client confirms. हम लोग patent draft करते हैं, file करते हैं. Day one पे we get this. I would say what we call as AFR, application filing receipt. Look at this. This is in the name of Dr. Rajni Athavale. यहाँ पे application number आता है, date of filing आता है, applicant नाम आते हैं, and then its title. So today I file a patent. I get this AFR or patent filing receipt. Now this is your NAC thing, NIRF thing. मेरा patent file हो गया very same moment. Use it in your CV, everywhere, whatever official documentation, on the very same day. Right? Now this is your first stage. Next stage, after 18 months, the patent application gets published. After 18 months, the patent application gets published. What all gets published? Look here. We have the application number, the same one which was there on day one. Date of filing. Look at this. The difference 24th March to 28th March 2018. Exactly after 18 months. Coming Friday जो होता है, so Friday is the patent office publication date. तो Friday को वो publish होगा. So 28th September is a Friday. It has a title, name of the applicant, name of the inventors, and the abstract. This is how it gets published. Now, patent office, what they have done, they have come up with an option wherein you pay some extra money, 2,500 rupees. That's for academic institutions. It gets published. How early it gets published? Generally within 1 month. But we have seen cases, we filed on Tuesday, Friday को publish हो गया, 72 hours में, 3 days में. That's how the patent office is active. Unlike if you file, but then need to remember this, all your forms जो भी filed है, those should be correct as such. 1, 2, 3, 5, 26 and form whatever forms are required. If they are correct, 3 days में, or let's presume within 1 month it gets published. Now we file request for examination. Then you get something called as a first examination report or FER. It is a FER, first examination report. That's how we call it. This is for an application for St. Xavier's. It has a date, and what does it include? It actually includes all these details, whatever we have been discussing. Novelty है कि नहीं, inventive step है कि नहीं, patentability under section 3(4) है कि नहीं, industrial applicability है कि नहीं, यही चीजें होती हैं. How will we taking it actually? We'll be seeing it as such. Now, what we do is, we file a reply. Now, this is coming from your MERU College of Pharmacy. We file a reply. So, we have 6 months time to file reply. जो भी objections आए हैं. Oh, okay, you in research paper you have that two-way communication to a research journal basically. They come up with an objection, you reply to that, you edit something. That's what we do here through FER reply. And rather this has 6 months. Now I'll tell you, ये objections, overcoming these becomes difficult if you have filed on your own. How? I'll show you because I have a live case हमने कैसे grant करवाया था, right? And it's a simple case anyone can understand. But this is the process. We file the reply, and then we get after this. Okay, at this stage as well, if the patent office is convinced that all the objections are met, patent office grants the patent. This, so when our quotation goes, it goes as a quotation from filing till grant. It has multiple steps. So the last step of hearing is not there in few cases. Rather, in last 10 cases, out of 10, 7 cases got granted for us after FER reply itself. That the controller was convinced, jo objections the, we have taken care of it actually. How we take care of it, I'll discuss it here. Now, if not, then the patent office gives you a hearing notice. Hearing notice would also have the same objections, novelty, section 3, obviousness, and all that stuff. Hearing notice is the first and the last opportunity to discuss one-to-one with the controller about your invention. And herein, if I am an agent, along with me, the inventors can join. This is virtual. एक महीना पहले notice आता है, एक महीना पहले आपको, like you would have an online link as, earlier it was offline, आपको patent office जाना पड़ता था. अभी it's not required. It's virtual. You can join for the hearing, and whatever, so it is like till date, everything was written communication, two-way communication written में था. Yes, you were submitting, e-filing it. Now is the time you have an opportunity to discuss one-to-one, because कभी-कभी क्या होता है, written communication doesn't give the message, right? So you convince the controller, and that's where I would say at times patent, you may require a help of a patent agent. FER reply and hearing के time पे. Filing, publication, request for examination as absolutely fine.
So at the time of hearing, what, as you said that at the time of hearing, agent is required along with the inventor.
No, it's not required. I'm not again saying it's not mandatory. You can manage on your own, but most of the times, I'll share you a case, ma'am, then you would understand that how difficult it is to manage on your own without the help of an agent.
But the inventor himself or herself knows that
Yes, yes. You understand the invention really well. I appreciate that actually, like, you know. I'll tell you what's the difference. In case of research paper, it's a purely a technical document. This is a techno-legal document. The claim language is a legal language. Okay, there is a very one famous quote about patent drafting. Patent drafting is an art, especially the claim drafting part. Claim drafting is an art to put the science in a legal manner. Okay, you are perfect. You may be quite smart as well. I have full confidence that you can do that basically. You are an artist, let's say. You have very articulative language and all. Put the science is like, you know, so you understand science better than me, I know that. Putting it in a legal manner, that's the challenge only. Maybe once I discuss the case, probably, yeah.
Just for the sake of the legal, so just for the sake of the legal aspect, we should hire an agent.
It's again, from day one it's been said, it is not mandatory. I'll tell you practically क्या होता है. First thing, especially for the academicians, पहली बात तो आपके पास time नहीं है, because half of your goes into criteria 1, 2, 3, 4, 5, 6, 7 for NAC or anything actually. Administrative stuff है, teaching है, research है. So you are kind of outsourcing it. That's the first thing as such. Secondly, practically क्या होता है? That's how we are working with most of the institutes or universities. Secondly, क्या होता है? Most of the times, once the, and yes, it's common. People file, the scientists, the professors file, the students file. Publish होता है, request for examination के बाद they come to us. The moment you get a examination report in your hand, सर ये मेरे को समझ में ही नहीं आ रहा. नॉवेल्टी तो है बोल रहा है, but why are they objecting in then? What do you mean by inventive step? How to prove that technical advantage or inventive step? It is a technical thing, but you need to understand how to actually come out of the right, I would say, right strategy, or how it should have actually, like, I would say, right approach, or how to show the differences between the prior art and your invention. आप ये बोलोगे वो 10 पेज का डॉक्यूमेंट है, मेरा 15 पेज है, that's not a difference. आप ये बोलोगे it is used in paint industry, mine is a cosmetic industry, that's not a difference. Technically ABC है वहाँ पे, you are working in a painting cosmetic industry, the same product is being used in the paint industry. Let's see. And publication, this is, imagine this is 15 years back, 10 साल पहले पुराना का story है ये, like, but then I said no, it won't get grant. नहीं sir, हम कुछ तो differentiate करेंगे, वो कुछ तो वाला part we couldn't convince the controller, and that became an obstacle. So that was refused. Okay, I'll take you through the live case now for patent. Everyone would understand this very easily. Simple example है. You understand mouthwash? Every one of you? Yes, backbenchers, the girls, students, yes, mouthwash समझ में आता है. Now this is an invention which we filed for BBDU, Bharati Vidyapeeth Deemed University, which is a herbal mouthwash. Which is a herbal mouthwash. Now, this is the product. So this is a claim basically, ma'am. This is the one which you have to draft, which you tried to draft yesterday. Now, right? What is this? Anyone knows this? We have a couple of pharmacists here. Targetus erecta is, करो Google करो, ChatGPT पे पूछो. It's marigold flower. झंडू है वो. 11th 12th में botany था, genus name, species name था. Targetus erecta is marigold. झेंडूची मराठी कळतं ना, झेंडूची फुलं. Okay, now herbal mouthwash composition. आता easy वाटतंय, right? The moment I say Targetus erect, but then controller would want this term because this is scientific, right? Now, a combination of sodium chloride, these are the other ingredients basically. Okay, any product has solvent, preservatives, stabilizer and other things actually. Simple product है, right? Novelty yes बोला है ना? Novelty कहाँ पे? The novelty is differs with the present claim in additional excipient like sodium bicarbonate, paraben, sorbitol, sodium chloride. Now, D1 and D2 disclose Zendu, mouthwash, solution, oral use. What it doesn't disclose? Sorbitol, sodium bicarbonate, paraben, and whatever solvent. Right? Now, no need of a scientific graduate or a pharmacist or an expert. Everyone knows that, or maybe those who are ordinary skilled in that, या जो pharma वाले लोग हैं उनको पता है, भित्रे सर है, यहाँ पे ममता है, all faculties. हमें तो पता है, these are the ones which are used in mouthwash. First year B Pharm, first और second Sutix का practical में यही करते हैं हम लोग. सबसे पहले हमें syrup solution ही बनाने को बोलते हैं. Right? तो ये use होता है. Now, controller, but controller has to show it. What he does is D3 discloses. D3 is a document which discloses a formulation comprising plant extract, not marigold, ना. कोई और plant extract है, उसका mouthwash which has sodium bicarbonate, sodium chloride, paraben, glycerin, sorbitol. So D1 discloses marigold mouthwash, D2 discloses ये सारे. But it becomes obvious, दोनों combine कर दो, मेरा product बन जाएगा. Where is the inventive step? Where is the technical advantage? Now, is it predictable? Is it obvious now? Is it obvious now? हाँ, एक में बोला है plant extract का mouthwash बनाना है, दूसरे में बोला है किसी और plant extract के mouthwash के साथ ये use करो. It's combine these. It's pretty obvious that you come up with the same product. Am I correct? Agreed? अब इसको overcome कीजिएगा on your own. This is exactly like, you know, जितने भी दुनिया में पेटेंट रिफ्यूज होते हैं, अगर 100 पेटेंट्स रिफ्यूज हो रहे हैं तो 95 आर बेस्ड ऑन ऑब्वियसनेस और इन्वेंटिव स्टेप. एंड हम जो भी पैसे लेते हैं ना, सिर्फ इसके लिए लेते हैं, हाउ टू शो दैट इन्वेंटिव स्टेप. नाउ आई विल टेल यू what all we had when we filed this application. When we filed this application, we had these working examples. If you see, the 6 batches, B1, B2, B3, B4, B5, B6. These were the 6 working examples we had. And of course, if you see, the B1 has just flower extract, leaf in B2, B3 में एक combination है. Like, you know, then there is a, these are the different concentrations basically with respect to various sodium chloride मीठ आहे ते सगळ्या mouthwash मध्ये असतं, right? खूप साधा product आहे हा, very simple product. But now, what data we had was this particular data. Maybe those of you who are from life sciences, microbiology or pharma, life sciences side can understand this data. This data is an antibacterial data which was conducted at a particular lab, which says that out of all these, B4 is the batch जिसमें maximum antibacterial effect है. B4 is the batch out of 6 batches. B4 is the batch which has a maximum antibacterial effect. ये data included है specification में और form 2 में. Now I have got a actually hint now. What I need to do is I need to amend this claim to include exact quantities. So what I did is, so they are saying B4 is the best batch. What I do is, instead of this claim, I put specific quantities. Extract of Targetus erecta, instead of that I say flower extract 1 gram. Combination of sodium chloride and उनका जो भी concentration लिखा है वो specific. And then I include all these quantities. I amend the claim. Okay, what we call generally जो claiming strategy है ना, it is a funnel shaped approach. What do you mean by funnel shape? Funnel देखा है? ऊपर broad and then it becomes narrow. The claiming strategy is always funnel shaped. पहला claim जो है वो broad होगा, जो कभी grant नहीं होगा. Now you need to foresee this, and that's where you had so the thesis was 200 pages. It had lot of data. I had to pick this data to convince or to understand that this data may help me, antibacterial activity B4 ka may help me to prove technical advantage. How technical advantage is shown and how it is non-obvious, I'll tell you. So what I tell the controller now is the D1, D2, D3 disclose antibacterial formulation of marigold with these excipients, absolutely fine. My claim is now amended to include the specific quantities. None of the documents D1 or D2 or D3 give me the exact quantities which would give me better antibacterial effect. So what is the technical advantage now? Or what is my invention? My invention is to select the right quantities. ये qualitative था. Now I made it quantitative. Select the right quantity and neither D1 और D2 क्या है? Simple documents है जहाँ पे general disclosure. किसी ने बोल दिया ये काम करता है, कोई त्याला हात पाय काय नहीं है. Just some random statement that acts as still acts as a prior art. But does it give you an idea of how much marigold flower extract you should take? Flower का लेना है या leaves का लेना है? कितना quantity लेना है sodium chloride का, sodium bicarbonate का? Right? I can give you an analogy. Those of you who know how to prepare food, right? कधी जेवण चांगलं बनतं, कधी गडबड होते, right? Those of you who are expert in that, they know कितना quantity of salt, यहाँ पे भी salt ही use किया है, कितना quantity of those spices or oil or I would say the anything that is a component that is required for that particular product. It's as simple as preparing tea as well. कभी-कभी बिगड़ जाता है if I start making actually, right? Now this is how we prove the inventive step. What is the inventive step? Or now my client has got a product which has a better antibacterial activity. Neither D1 nor D2 or D3 provide this composition or any hint to anyone. Just based on these three documents, can you come up with this before batch? नहीं, अच्छा इसने 6 batches क्यों किए? This is exactly how we work in lab, right? We try multiple things and out of that we select. Now, okay, the most significant part, and this is I would call it as a trade secret of patent agents. You can definitely, if you are drafting on your own, you can do this. The most significant part, when you are drafting a research paper, you just include positive results. Am I correct? उसी के basis पे आपका research paper accept होता है. Patent के document में हमेशा comparative negative results include करो. It gives you an idea or hint how to prove the inventive step or technical advantage. Ab, can you foresee all these things? The funnel shaped approach. What was my funnel shaped approach? Funnel shaped approach was पहले qualitative रखो, फिर quantitative रखो, and उसके बाद में we had a third layer actually, which was process and not the product. There is a way they the same product prepared by multiple processes. So we had those 3-layer approach basically. Right now, after this, of course, there were other objections as well, and we got it granted, by the way, with the claims, these claims with the quantities in B4. With the quantities in B4. I have an interesting thing here. ये क्लेम में एक गड़बड़ है, क्या है? This was drafted by my team.
Concentrations are missing.
That's not mandatory. Initially filed claims में, that's not mandatory. Yeah. No, you are allowed. It's broad. Not necessary. This is broad. Funnel shape में ये broad है. You can इसका okay. What is claim basically? I'll tell you. अच्छा, आपका जब अगर land है ना, तो you have those borders कि left में इनका बंगला है, आगे road है, right में मंदिर है and पीछे ground है, ऐसा. Those borders. Now यहाँ पे borders क्या है? When you say solvent is not mentioned, all solvents are covered. And no, someone was saying that. No, it's not mandatory. It covers every value. It covers every value. When, try to understand the scope now. This covers every value of extract of target is 0.01 से लेके whatever you can imagine. It covers all this. Qualitative means. No, it's not required. Even last में भी हमने नहीं include किया. It's pretty easy, हाँ. Just एक बार read करो तो अपने आप समझ में आएगा. हाँ? Exactly, yes. Now I'll tell you what objection we got here. Okay. Claim 1 recites both a combination of sodium chloride and bicarbonate and sodium bicarbonate. Thus, the proportion of sodium bicarbonate in composition claim 1 is not clear. Claim draft किया हुआ हम लोग interpret नहीं कर सकते. However, we kind of gonna draft a claim and actually interpret it and convince the controller based on the technical arguments basically. We got this? Of course, we have that opportunity to change this basically. हमने क्या किया? एक हटा दिया. But then that was the correct thing actually. It is repeated, right? In a formulation, in a why is it necessary? एक combination है and एक independent है, that's fine, but it's not, in a qualitative composition, it's not necessary to use it as a combo basically. Right? So this was also an objection basically. But we got this granted with this specific example only. So 1 gram, these quantities. This is how lab से patent grant तक का journey होता है. Right, you get a FER, we attended the hearing. Of course, there was there is also a okay, I'll tell you an interesting fact which was like, asked in, I happened to be in Jamnagar, Gujarat last week. Therein one question was asked to me is, sir, is there an opportunity for third parties to oppose the patent? Yes, there is an opportunity. Patent office is, we have a pre-grant opposition system. दुनिया में कोई भी बंदा आपका पेटेंट अपोज कर सकता है. Think of your own internal rivalries. Or the way Sadhguru says, कर्मा. आपका अभी तक का कर्मा किसी को तो आपने हर्ट किया होगा. The moment you have a patent application in public domain, वो किसी और को हर्ट नहीं किया तो हो सकता है किसी पेटेंट एजेंट को ही हर्ट किया होगा आपने. वो opposition file कर देगा. The moment you have an opposition file, right? Am I correct? Right. Now, okay, and this journey many a times, I think, in this specific case, if you see, जो ताटके मैडम का application था, this was 13 का application, 2013 में file था, and हमारा FER was in 2020, 7 साल. अब वो ग्रांट होते होते 8 या 9 साल लगा था. पेटेंट ऑफिस थोड़ा सा अभी फास्ट हुआ है. आई डोंट वांट टू बिकॉज इट्स लाइव रिकॉर्डिंग, आई कांट कमेंट मच ऑन दैट. बट this was pretty old. Of course, like the things are pretty fast nowadays. But then, why isn't? Probably answer lies in these dates or the tenure as well. Now this is all about patent. I'll take you through another interesting case because we've been discussing about design a lot since last 2 days, and after that, I would say Janvika rockstar performance yesterday. I thought I would include something related to design as an example, जो हमने किया हुआ है PV Polytechnic के साथ, which we got registered as well. Now, rather I'll tell you, because since you asked कि हम लोग can we file on your own, patent techno legal है, थोड़ा सा challenging है. Design is super easy. On your own you can do. Of course, design में वैसे हम लोग agent लोग ज़्यादा पैसे भी नहीं लेते, but you can do that very easily. Look at this. These are the only 2 forms. Okay, if you look at this, is it visible? Thoda sa, like, you know. Now, this is Dr. Sachin Ladda, Madan Kendre, and Vrishtisha. ये jewelry design का है. This is a view, actually we have called this as a 3D view. 3D view means perspective view. Okay. This is a ring basically. Novelty resides in the, this is a finger ring basically. Something like this. So if you look at this, unique shape hai. Right? Ye maybe once you see, thoda sa clearly देखोगे तो, like you know, you may, थोड़ा सा clarity बढ़ा सकते हैं इसका, देखना. ये image का एक बार. हाँ, zoom कर दो, absolutely. The image. थोड़ा सा left. Left. और थोड़ा. Oh, perfect. Now it's, अभी दिख रहा है? Now this was the one which was part of their project actually. This is a ring. Honestly, मुझे दिया नहीं था, मुझे नहीं पता कैसे पहनते हैं इसको, like you know, because it looks a bit different. इतना तो समझ में आ रहा है. We filed this, so this is a 3D view, but as we discussed yesterday, if this is the product, you need to show a top view, bottom view, maybe ये symmetrical है तो fine, you can have any one view. Front view or back view would be the same, or side view would be the same, without any names, trademarks and all, actually, like you know, all these things. So for example, if you see this, like you know, there are some kind of grooves you can say here, right? These should be very clearly visible. हमें objections ऐसे ही आते हैं. What the examiner does is, he tries to imagine the product in every view. अगर ऐसे दिख रहा है and ऐसे दिख रहा है, minor difference आया तो objection आएगा. Simple है. ये तो कोई भी कर सकता है, right? And so filing design is comparatively easy. I'll tell you how to file it as well. As I think what was covered yesterday as well, like you know, you need to have full product. मतलब front view है तो सिर्फ ये part दिखा, ऐसा नहीं. ऐसे put it like this, take a photograph. Put it like this, take a photograph. Now in this case only one view was provided. Now you can go to the normal mode. No, I want to see that entire page. All right. Full screen. So this is Dr. Sachin Ladda. थोड़ा सा ऊपर जाना पड़ेगा आपको. Okay, got it. Yeah. This is Dr. Sachin Ladda, Madan Kendre, Vrishtisha. This is the 3D view. Novelty. आपको यहाँ पे क्या करना है? यहाँ पे claiming वगैरह कुछ नहीं है, मैडम. यहाँ पे सिर्फ आपको देना है novelty कहाँ पे. What we said, the novelty resides in the shape and configuration of finger ring. Okay. Now, so there is this disclaimer. This is a standard format. This is one what we call as a representation sheet. You need to provide multiple representation sheets. Rather, 2 दिन से I have been hearing this, like you know, rather for these kind of projects, even I would say your own kids who are small, they can also come up with these kind of products जो घर पे भी बना रहे हैं या ऐसे so it's pretty much possible. Now what is important in this is ये बहुत easy है, representation sheet कर दिया, and then you have the form 1 which includes the names, the nationalities, the address, and the most significant part is कल जो different classes देखे थे ना, if you recollect कल क्या हुआ था, classes 1 to 32, right? You need to select the right class. 11 was articles of adornment. उसमें sub categories आता है. All this is called as Locarno classification, which is available online. Locarno, Locarno classification, which is available online. The only thing that an agent does in this is he or she identifies the right class for you. And then of course you need to have digital signature, so you put it that way. And just for your information, without examination this got granted. Patent without examination generally grant नहीं होता है. We have never seen. एक बार तो ना there is just one case. I was always curious to know कि हमें कोई एक case हो जो बिना FER के grant हो. But then the examiner was like, उसने कोई minor I would say grammatical error निकाला claim में. That was the only one objection in the examination report. That got. But in design के case में you don't need basically the so this got granted without examination within a month. एक महीने में this got registered. This is the certificate for that, registration of design. You have the design number, all the names are here with the signature at that point of time. I think this was filed somewhere in 2021. We had filed almost, I think, 10 designs for that particular batch of jewelry design students as such, and all of them actually literally got registered with the patent office as such. So I'm done with my session. Of course, we have 10 more minutes, I would say, and I'll be happy to answer if there are any specific questions with respect to, like, of course, we have been discussing this, we have been seeing a lot of case studies. अभी मुझे लगता है live देखने के बाद you would get better clarity how to do, what not to do basically, and whether to do on my own or hire a, I would say, a smart patent agent. Yes, any questions? Yes.
In the field of mechanical technology is concerned, and suppose the research work is related to the certain process, machining processes, the research work goes on.
Yeah.
And in that case, how the examination is done?
The processes?
That means the process and that particular research work is done in that particular way. Now, how the representation is, and as far as examination is there.
Okay. So the design is always for the products. Design. Patent is for the processes. Process के लिए आपको design नहीं होगा. How it looks, how it looks. So for example, how the ring looks, that's what can be protected. It's aesthetic look, right? But then if you are saying ki how this was prepared, cannot be put under the design. Na? It can be put under actually, like, the patent thing as such. वहाँ पे you mentioned the different stages of like, I would say, or the manufacturing process basically. Yeah. And you need to come up with, I would say, technical advantage as well as the different processes, the steps, how they are different. Because आप जब steps की बात करोगे, तो if you remember, there is one specific section 3F which says arrangement or rearrangement. अगर आपने कहीं और से वो arrange और rearrange किया, तो you won't get it granted. I'll tell you maybe, yes sir, please.
In such case, how the examination is conducted?
They check the steps basically.
Achha.
Okay.
Practically, we don't have to show the demo and all this.
Nowhere. Okay. I'll tell you, patent office never asks it, firstly. Secondly, अगर उनको product technology ही समझ में नहीं आ रहा, in that case they can ask for a model just to be shown. आपको just लेके जाना पड़ेगा. And if you don't have model, सर इसकी जरूरत ही नहीं पड़ती. हम लोग जो hearing है वहाँ पे समझा देते हैं, like you know, hypothetically उनको समझा देते हैं या ऐसे, like you know, it is rarely that they ask for a model actually. They are allowed to ask, okay, but then, and I'll tell you the process ka, because you mentioned about process. How to prepare tea, chai kaise banate hain? Let's try to understand it, and I'll tell you how to draft it actually. You tell me one by one steps, and I'll tell you how. So my claim is very simple. A process for preparing tea comprising, okay, क्या क्या करना है? Take a pan, add boiling water, add water and boil it, okay?
Sugar.
Add tea powder, okay? Add ginger, okay? Very nice. I like ginger tea. Next, add sugar. किसी को sugar है तो क्या करोगे?
Jaggery.
How to put it? Optionally. Oh, wonderful. Ma'am, like you know, मेरे next मतलब team में next recruitment जब हो रहा है तो I'll get back to you, like you know, we can work out something. I'll put optionally adding sugar. What else? एक ऑप्शनल हो गए तो सारे ऑप्शनल कर दिए. चलो, adding milk, optional.
Black tea.
Now, yes. Now, मैंने क्या बोला? चाय बनानी है. Now, चाय, actually, you know, there is a term, a patent, जो मैंने सुबह से बोले जा रहा हूँ, patent claim drafting is a art to put the science in a legal way. अब मैंने चाय बोली है, चाय के जो types है, वो सारे उसमें cover करने हैं आपको. तो like you know milk tea or like you know what you call it black tea. मैम को black tea चाहिए, वो भी cover करना है. Next, what next? Yes? Ginger हो गया. Ilaichi, okay, wonderful. What else? Tea masala, Gen Z. Next. Flavors, okay. Lemon tea, okay, wonderful. Sugar, brown sugar मैंने वो वाला नहीं बोल रहे ना मैम आप. Jaggery, okay. Yes, गुड़ाचा चाय में तो आजकल. Honey. Stevia मतलब क्या बोल?
तुलसी, sugar.
अच्छा, okay, sorry. मी like लातूरचा गावाकडचा या टर्म्स कळत नाहीत बऱ्याचदा. What else? Come on class. Turn on the flame. That's the most important thing. उन्होंने boiling बोला. I'll tell you an interesting. I conduct these presentation classes. मैंने exercise यही दिया था. After entire 50 hours preparation, जब ऑफलाइन क्लास हुई, सबको मैंने चाय बनाने का प्रोसेस क्लेम ड्राफ्ट करो बोला. Half of them missed the word boiling or putting the burner on. Half of them. तो मेथड तो बता रहे हैं हम लोग, बट जब तक आपको इंग्रेडिएंट नहीं पता है, एग्जैक्टली तो वो मेथड ही आप क्लेम करना है आपको मैडम. How I'll put it now is a process for preparing tea comprising, क्या फर्स्ट स्टेप क्या था ममता? सॉरी. taking water. Now सुनो अभी खत्म नहीं हुआ स्टोरी. When I say taking water, तो मेरी जो क्यूटी पाई बेटी है ना 5 साल की, उसके पास इत्तू सा कप है, वो हर रोज मेरे को एक्चुअल चाय से पहले, पापा मैंने चाय बनाई है, तुमको पीनी पड़ेगी, नहीं तो मेरा दिन खराब हो जाएगा, ऐसे बोलती है वो। मतलब इमोशनल अत्याचार है पूरा। नाउ हाउ वुड यू पुट इट इन द क्लेम? कितना क्वांटिटी लेना है? पर 200 ml। अच्छा, अब मैं ये लिखूं क्या, a method of preparing tea for one person? अच्छा, तो मतलब ममता, मतलब लाइक यू नो, आपने अगर एक बंदे का चाय बनाया तो किसी और ने 2 बंदे का बनाया तो नॉन इन्फ्रिंजिंग हो गया। How will I put it? Method standard ही है मैडम। How would I put it in the language? A method of preparing tea comprising, let's say taking so I'll tell you smartly how to put it. Taking so that's where you need a agent. Taking a suitable quantity of water, okay, in a pan. Next step is putting the flame on or whatever, burner on, like you know, and of course you have to mention it कि वो pan उसी burner के ऊपर है. That also need to be mentioned. Class, am I correct? Yes. So like you know, because what we write may have multiple meanings, right? Now, this is your second step. Third step is मैम, ये मुझे प्रॉब्लम्स पता है, ये प्रॉब्लम्स मुझे पता है। मैंने अपनी बीवी को आज तक ये नहीं बताया कि मैं चाय बना सकता हूँ, क्योंकि मुझे पता है कुछ ना कुछ तो। See, I'll tell you, in fact, you know, this is the first step we do in patent agent training. हम लोग सबसे पहले ना बाकी लोगों ने जो ड्राफ्ट किया है वो दिखाते हैं। दूसरों की गलतियां निकालना आसान है, जो मैं ड्राफ्ट कर रहा हूं उसमें गलतियां निकाल रही है ये मैडम, बट इफ आई टेल यू टू ड्राफ्ट इट बिकम्स डिफिकल्ट, देन यू ड्राफ्ट इट, कम ऑन, इट्स इजी एक्चुअली, लाइक यू नो, यू ड्राफ्ट इट एंड मैं फिर गलतियां निकालता हूं, एंड देन इट बिकम्स डिफिकल्ट आंसर. Now that's the second thing. Third thing I'll put is optionally putting, I won't call it sugar, sweetener. The right term I'll use it, sweetener. That's an independent claim. And in a dependent claim I would say the process as claimed in claim 1, wherein the sweetener is white sugar, आपका brown sugar, jaggery, what else? Stevia, right? That's the term. तो सारे कवर हो गए, गॉट इट? तो ब्रॉड क्लेम, अभी देखो मेरा फनल शेप्ड अप्रोच में फर्स्ट क्लेम कवर्स ऑल स्वीटनर्स, बट इसमें एक रिस्क है. क्या रिस्क है मैं बताता हूं. द रिस्क इज दैट अगर कोई प्रायर आर्ट शुगर मेंशन करता है ना, तो सारे स्वीटनर्स के लिए वो प्रायर आर्ट एक्ट करेगा. आई करेक्ट? बट इफ आई पुट जैगरी, शुगर में नॉट एक्ट एज अ प्रायर आर्ट फॉर जैगरी. एम आई करेक्ट? तो आपको स्वीटनर इंक्लूड करना है या शुगर इंक्लूड करना है, ये पेटेंट एजेंट ही बताएगा. नेक्स्ट, ऑप्शनली एडिंग. तो ऑफ कोर्स शुगर वाज आल्सो, सम पीपल डिड said sugar भी optionally, but I'll tell you there is a problem then. Optionally ना many a times the patent office says नहीं, it becomes really very broad actually. आपने हर चीज को ही optionally, मतलब सिर्फ पानी और अपने टी पाउडर ही डालना है. It's simple mixing, section 3E में आ जाएगा. Simple admixtures are not allowed. So how would you make that process? Adding, let's say, the tea powder again in a suitable quantity. No, process में it would work. मैम क्वांटिटी तो मैंने इंक्लूड करना है, but not day 1 पे. Funnel shaped approach में, see, I have some objects. क्या है ना, एक ह्यूमन टेंडेंसी है, जब बॉस के पास छुट्टी मांगने जाते हैं, दिस टिपिकली वर्क्स इन कॉर्पोरेट, फर्स्ट टाइम में छुट्टी नहीं मिलती है. यू गो कन्विंस, थोड़ा बोल के वापस, ओ दे ही और शी वुड कॉल यू अगेन इन द इवनिंग, अच्छा शाम को मिल यार, मैं अभी बिजी हूं. राइट नाउ यू फाइल अ पेटेंट एप्लीकेशन. As I said, not a single application has been granted without examination. तो वो ऑटोमेटिकली कुछ ना कुछ तो नुक्स निकालेगा. Now in a funnel shaped approach, अगर मैं क्वांटिटीज ही डे 1 पे इंक्लूड करता हूं, उससे नैरो कैसे करूंगा बाद में? What I'll do is, डे 1 पे अगर डे 1 पे ही मेरे क्लेम में क्वांटिटीज होती, वो कुछ ना कुछ ऑब्जेक्शन लेके आता. इससे और नीचे कहां जाऊं? Do I have an option to narrow it down further in a funnel shaped approach? Absolutely no option. What I do is, I put it without quantities initially. If there is an objection, तो क्या है ना, so okay, trade secret बता रहा हूं, let it go on record actually, like you know, आप जब एग्जामिनेशन रिपोर्ट आता है ना, something like this, there are 6-7 objections. The first thing that you have to do is accept few of the objections. जब घर जाते हैं, सर को एक्सपीरियंस है, सर ने विदाउट एग्जाम्पल हंसना स्टार्ट कर दिया. जब घर जाते हैं, let's say, I'm just giving you an analogy, it doesn't happen at a patent office. जब घर जाते हैं, बीवी गुस्सा है, 4 या 5 रीजंस है, द वेरी फर्स्ट थिंग यू डू इज, 2-3 एक्सेप्ट कर लो. सर तो सारे एक्सेप्ट कर लेते हैं, बट सारे एक्सेप्ट कर लोगे तो पेटेंट रिफ्यूज हो जाएगा. 2-3 एक्सेप्ट कर लो ना, 1-2 ऑब्जेक्शंस को. सो इनफैक्ट इवन ड्यूरिंग हियरिंग, इफ यू हैव 5 ऑब्जेक्शंस, हम लोग क्या करेंगे पता है? It's okay, how you negotiate, how you deal with any individual basically, like you know, every individual need to be like you know, especially during negotiations, let's say, I'll try to accept my mistakes first. सामने वाला थोड़ा तो calm down हो जाएगा. Now these are trade secrets, cannot be spoken on live camera. But then you actually start amending the claim, or I would say थोड़ा सा narrow करो and come up with, see at the end क्या है, मेरे क्लाइंट को ये नहीं फर्क पड़ता कि ये क्लेम ग्रांट हुआ है कि नहीं, उसको ये फर्क पड़ता है कि मेरे को पेटेंट मिला है कि नहीं, क्या है अंदर. no one is bothered, and it's just not you, I'm telling you, you are doing it for NAC and IRF. I worked with one of the biggest corporates in pharma industry, life sciences, 2007 to 9 में. मेरे LinkedIn प्रोफाइल पे देख लो, what organization, that organization filed 200 patents in a year. I was curious to know, ऐसा क्या research कर रहे हो तुम लोग? Honestly, the reason therein is they are filing it, the numbers for the investor purpose. सब बड़ी बड़ी conference में जाके showcase कर रहे, we are research driven company, and let me tell you, it was on the verge of bankruptcy in 2011. After filing those 200 patents, not because 200 patents got filed, but for some other reason. So it is all about showcasing it actually, like you know, why do the startups do it? Startups wala to, the community is really very different the line, especially when the Gen Zs are involved. Or what is that term? Boozy, right? That's what has been used since. I heard that term for the first time yesterday actually, like you know. We come up with some invention, like you know, simple hair, but then we want patent. Why? There is a value added, okay? What happens is, as a layman, as a consumer, the moment we say it is patent protected, patented, 2 effects होते हैं. People feel it is innovative. A patent में क्या है किसी को नहीं पता. Firstly, and secondly, competitors पे to some extent deterrent effect होता है. That's the reason they are actually filing all those IPR or the patent or design as such, right? बनाने की प्रोसेस इजी जितनी लगती है उतना ही वो ड्राफ्टिंग डिफिकल्ट. चाय बनाना सबको पता है, फिर भी वो यू कैंट पुट इट इन अ प्रॉपर शेप बेसिकली. सिमिलर वे से आपका इन्वेंशन जब आप सो इन द पेटेंट ड्राफ्टिंग एज आई सेड everyone can do it very easily, rather it's very easy. Only claim drafting is difficult, and probably that's the reason we are taking that money. Yes. Any other questions? Yeah.
What are the exactly charges if we hire the agent only for this?
Only for?
Hello.
Yeah.
Sir, my question is, what is exactly the charges if I want to hire an agent only for the two reasons? One is for the claim drafting and another is for if there could be any objections and I'm facing the examination. So at that time. So I need only this two kinds of helps. Rather the whole work will be of mine. So is there any discount? So more of financial point of view.
No, very nice question.
Thank you.
What are the charges for a student who comes to university only for exam? Is it allowed firstly? Or does university allow? नहीं मैम मेरे को तो डिग्री चाहिए, एग्जाम ही दूं, मैं तो घर पे पढ़ लूंगी. Students are so happy, ma'am. Okay, I would say again it all depends again on the agents, what practices they do and all. Honestly, we are not doing this generally basically because like, you know, it's an entire process as such, like, you know, from ideation till grant, the entire chain, and it is generally like, you know, if one person is involved, at least we can, I would say the responsibility lies with the person for drafting se leke grant tak. Now in these kind of cases what we have observed, we did it actually earlier as well, in fact, like, you know, for a few cases, but what happens is if it doesn't get granted, aapka paisa chala gaya, and that point of time we are honestly it's very difficult to be a service provider. We are at blame ki nahi aapne theek se nahi kiya. Honestly we are doing it, it's not like we are not doing it actually. So jo generally jo filing se grant tak ka on an average, the way we are working with SNDT or other universities, 60 to 70,000 is the maximum cost. That's the maximum cost. In few cases, there are no hearings. Let's say the cost cut down ho jayega. Few things are optional. Early publication is optional. 60 to 70 over a period of 4 years, 3 to 4 years. That's the cost actually. Yeah. For design, it's just 10,000 maximum, like, you know, for individual, and for if it's in the name of institute, it would be, let's say, 15 to 16,000 from filing to grant. Yes, but then Kapila ke बारे में बोला गया, you need to check your eligibility for Kapila first. Kapila doesn't give it to everyone. 100 inventions बोला गया है वो, but then Kapila is giving, I think it's a AICT scheme. आपका अगर IIC active है, and IIC कुछ conditions है, based on that only Kapila is given. Rather what Kapila did is, I'll tell you, it's not, it's, yes sir, पैसा government से भी निकालना इतना easy नहीं है ना, right? So in fact what because we work with a client, Kapila did one very nice thing, I would say. I think this year when it was like, earlier it was just, I would say, per institute 5 and 10 inventions. This year when they did 100, they did one nice thing actually, like, you know, they said पिछले 6-7 साल में जितने filings किए हैं ना, वो सारे दे दो हमें. And my client was like running after me, sir, उसका वो receipt दे दो sir, filing receipt and RFE receipt. It's 5,600, 1,600 for filing and 4,000 for the request for exams. Yeah, 5,600. But then they were still happy because उस institute के लिए हमने almost we had filed 30 applications in last 8 years actually. तो वो they didn't know there is no money coming. It's a cost center. एकदम से 5,600 into 30 like almost 1.5 lakh आ गया. They said चलो और 2 patent file कर दो विजय. Eventually, and this is like, you know, okay, I'll tell you another scheme which has never been discussed. NEP, New Education Policy, allows you to have your own ventures, have your own startups, the company is in your name. Okay. There are 2 schemes. One is SIPP scheme by Patent Office. आपको वहां पे सिर्फ ऑफिशियल फीस देना है, बाकी the entire cost is borne by the Patent Office. Now Patent Office, they don't do on their own. They are, so I am also one of the SIPP facilitator. SIPP is startup some facilitation scheme. You can just check it on the, and there is a list of facilitator. Okay, startup innovations, ma'am, I don't recollect exactly. So under that scheme, you don't need to pay, आप सिर्फ official fees. Now on one side, Patent Office is saying, like, you know, unofficially that don't hire agents, fine. But then जो scheme है government का, वो agent ही file कर रहे हैं. That's one scheme that you can bet. But this is only when you have the Ministry of Commerce and Industries gives you a startup registration certificate, which is completely free of cost. You need to register your company. एक CS से बात करो, कोई भी company register करो. आपका like, you know, for that you can get facility, like, you know, this benefit of SIPP scheme. Second scheme is by Ministry of MSME. This is more important. For any MSME, I think there was someone who mentioned we have this jewelry ka shop or something like, you know, designer ka ye actually, like, you know, if it is registered and if you have a Udyog Aadhar, those of you who are in business, they understand what is Udyog Aadhar. You have Aadhar, similarly the businesses have a Udyog Aadhar. If you have Udyog Aadhar, it is also called as a MSME registration certificate. In that case, for patent, you have full 1 lakh reimbursement for Indian patent. Full 1 lakh reimbursement. 5 lakh reimbursement for foreign patent. Trademark, I think it goes up to 15,000 and design goes up to 10,000 per patent, per design, any numbers. आप अगर 100 patents file करके grant करते हो, then in that case you may get that 100 into 1 lakh, but that's a reimbursement. आप पहले expenses करो and get it reimbursed. Yesterday I was at a meeting at Andheri West actually. The client is a MSME. Last week they got full reimbursement. You don't need to do anything else. Everything is online. MSME innovative scheme है वो. Portal पे जाके सारे bills attach करने हैं, patent number attach करना है. You get it directly on your account. Agent का पैसा भी, मेरा bill भी, but provided you are a MSME. Earlier it was not allowed. NEP allows you to do that. NEP, with the permission of the university or your institute, you are now allowed. पहले क्या होता था? कोई भी teacher, professor, if he is having his setup, it was not considered as a good thing. It was considered as a conflict of interest. Right? Now, the NEP says, no, you do that. There is no problem. And if you do that, you have MSME authorization, you get that reimbursement. ठीक है?
So it's basically algorithm is already taken and we add up the steps, we just move certain steps into that. So as you said that the running application is not required. So in our case, we do actually run and get the test cases and get the outputs, and then we claim that, okay, this output is better than the earlier one which we have taken actually. So how exactly in this case I'll be putting it
softwares
up?
are not eligible for patents. You go for copyright, and copyright is minor change if you get a copyright for that.
Okay, so in this case, I won't be able to go for a patent.
So, okay. In India, we have a system, the software need to be connected to a hardware.
Okay.
And the novelty need not be in the algorithm. It should be in that mic or the hardware. Ma'am, day in day out we deal with the startups, and ये India का पूरा startup ecosystem is just, I would say, most of the startups are just based on some algorithms, and okay, many of them are just mere aggregators. Code ही तो बना रहे हैं, बाकी कुछ नहीं है, right? So they come to us, and that's where we come up with a hardware connected. So okay, hardware connected. I'll tell you how it can work. I can give you the example from my industry, or even during COVID, we had these diagnostic kits. That diagnostic kit connected to a app or a website. Now that kit is novel, then you can get hardware plus software.
Okay.
But then the kit or the hardware need to be new, not the your
Only the
algorithm.
software algorithm.
Algorithm, yes.
So if I go for the copyright, in that case, the copyright is applicable to this, right?
So I think, I don't know whether you were present on day 1
I was there.
or day 2, wherein I discussed the moment you create, you get the copyright. You don't need to register.
Okay.
You have automatically the copyright.
So I think in the biomedical sector, those machines are there, like ventilator or all this. They could be having patent.
So again, try to understand this.
See, because in biomedical sector,
Yes, so scientific inventions में तो patent file होते हैं. That's the reason in many times you have the monopolies created actually. Okay, thank you so much. I'm sure, my time is over, and I have to also rush for another meeting. So, but then we'll be connecting tomorrow with very interesting topics related to the IP policy, how to frame, what are the key challenges, what are the problems in the IP policy and all. Thank you so much.